In this essential series, we're going to be giving short, simple insights designed to help everybody navigate the real stuff. No fluff, just practical guidance so that all of you can move forward with some clarity. And as always, none of this stuff is going to save the world, but I can promise it won't make it worse. Welcome to Outsider Information. I am your host, Brandon, and your strategic partner here with OYAS. As always, if anything resonates, give a like, subscribe, and engage, not just here on Instagram. And I would check out the website. I think it's pretty cool. Drink of the episode, just like the shirt that has not changed as I've recorded this series, is still water. I've just topped it off and threw in a new lemon wedge as well because we are fancy around here, right? As I have stated previously, this is not legal advice. If you do have any situation that requires, there's the disclaimer by the way, if you have any situation that requires intervention via an attorney or have questions about your rights as an employee, I would highly advise contacting a lawyer that specializes in employment law. All right, so we've covered different topics throughout this series. This one is the ADA, the Americans with Disabilities Act. And the ADA is complicated because there is no real way to determine a lot of factors that lead into it. But it's there for the protection of the employee to prevent anyone from retaliation against somebody who may have a disability, marginalization in the workplace, ensuring that you have what it is you need to be successful at your job. And that is why it is in place. It is one of the many things that exist in the world of employment law that are there to help. And it is your right as an employee to ask about an accommodation at the workplace. Anybody can do it. Anybody can use it. You just have to understand how the process works. And darn it, that is why we are here today. But before we get into that, the ADA is a legal minefield because there is no uniform way on how to apply it. Now, when I say that, right, it looks different in every setting, every organization. Even within the same organization, it could look different in each department of how and what is reasonable. And that is the word that we are going to cling to, reasonable accommodations, because you cannot just ask for anything. You have to, or when you do ask for something, there is a process to determine whether or not it can be accommodated. Similar to what we talked about in the work comp video with restrictions. If your workplace is unable to accommodate it, there are other steps. And we are going to talk about what that is as it relates to the ADA. Now, some examples of how it's applied. Some accommodations that I saw a lot of were desks, technology, programs, breaks in the day, having additional time to take your medication if you have diabetes and have to take shots or anything of the sorts. Those are all examples of things that can be built in to what you do at work in a way that grants you an accommodation without penalty. Pregnancy accommodations, those are state policies and those exist differently. We had one that gave accommodations to pregnant mothers, right? Additional food, seating, and bathroom breaks. Once the child was born, a space to pump that had a sink. That was the specific piece that we had in there, was that you had to have a sink. That was a state policy. Going back to the word reasonable, is what makes it hard is reasonable creates unreasonable scenarios, because what's reasonable to one might not be reasonable to another. And negotiate is the wrong word, but you do have to massage the process a bit. I will say just right off the top, consistency is the best way to prevent a disaster. I would highly, highly recommend you taking a look at every accommodation you have or have had, try to find a trend, and use that to kind of create a baseline for what reasonable is by certain positions. It is not impossible, but it is hard because you have to really commit to the process. What is the process? It is always self-activated. As an employer, we can suggest, recommend, mention that accommodations are available. We cannot force you to take an accommodation that you don't want. That is fact. If you ask for an accommodation, that activates the process, or you inquire about it. That was my role. Again, in a different role, I held one role that did leave, accommodations, and work comp all bundled up into one. Also have a doctoral degree in human resources, if that matters. So I'm not just telling you this. I'm telling you this having experienced it, done it, and studied some of it. Where it goes from there when it comes to the engaged process, the informed process, that is what it's called. As an employer, we have an obligation to you as an employee to go through the engaged and informed process of how the accommodations work, how we determine reasonable versus unreasonable, basically giving you all of the information that is needed in order to process it. Now, it's very document based, much like with leaves and work comp. We cannot do anything unless we have documentation to support it. And if you have a provider willing to sign off on it, that makes it much easier to kind of help things move forward. A lot of times when I did the process, I had some of these accommodations that we just knew exactly what they were for, right? And I knew exactly the verbiage that needed to be on there. If you needed to take meds at work, if you needed mental health breaks, I told them what to say just so that I knew how to process it. And that was just how I did it, because the organization I was with did a terrible job with the ADA because they basically let everything happen. And again, it created minefields because we had no way to determine or undetermine what reasonable was. Something you want to avoid, and there's no real way to avoid it, but you don't want to use the ADA to try to save a job or save someone's job, because when performance concerns kind of start getting in the way of things and suddenly there's an accommodation attached to it, it just creates a whole separate problem that could have been prevented if things were managed the right way, because now you potentially find yourself in the position where you could be terminating somebody with an active accommodation, and depending on how it's done and how well it's done could open you up for a lawsuit as an organization. When we discuss the issue of the accommodation, we want to know what the ask is. That's always what I want to know. What do you need? What are you asking for? How do we make this happen? Not everything is possible or even reasonable, but what is your threshold to navigate that? And that is where you as an organization, I'll go back to what I said at the beginning, need to have something in place that allows you to do that, because if you don't, you're going to have a whole lot of problems on your hand, and it's going to be something where you're going to have to detonate the whole thing in order to make it manageable again. The danger companies have is either doing too much or too little, and you really want to find that sweet spot. If you are inconsistent with how it's applied, granting an accommodation in the past, not granting it in the future, you're opening yourself up for jeopardy. Not defining what reasonable is, problematic, especially because in my role, there were a lot of things that weren't reasonable that I ended up having to push through because we didn't have a clear definition of it, and they were really scared about somebody coming back at them. As an organization, you have to set your policy and you have to go from there. There's no wrong way to do it. You can't be afraid to say no. And as an employee, you have to know how to go through the process as well. You are not limited by this. The worst you can do is ask. And if they say no, they should be able to find a workaround to get you the thing that you need. For employees, the ADA is there for your protection. It can buy you some time if you do need it, but it cannot save your job. Now, when it comes to this accommodation, where I saw it a lot with performance concerns, if somebody was being written up, they would disclose something, and then we would find a way to build this accommodation in to help for a short amount of time, and then it just really kind of fizzled out from there. If you are concerned about your ability to do the job because of an issue that you have, you need an accommodation, bring it up as soon as you can, because again, that is going to help you through the process. It is there to help you do your job. And please don't weaponize it, because like with anything, we talk about things like racism, assaults. When people make up stories about that, it makes it that much harder for people that genuinely need it. And the ADA is there for those who need it. Ask questions about how it applies to you. That is important. You're not weak for wanting or needing help. That is what it's there for. On a side note, not that employers legally can do this, but let's be honest, hiring is discriminatory. I would advise disclosing any need for an accommodation until after you are hired, things are signed, and then you can kind of go from there. Unless it is something major and drastic, most accommodations typically are not. I would sign your offer letter and get in the building and then disclose that you need an accommodation. That way, there is no way human nature can get in the way of it. All right. So what really matters, this is the most important aspect, is does it cause an undue hardship at work? When any accommodation is brought up, that is the assessment that I had to make. Have we done this before? Is it reasonable? Is it equitable? And if we do put this in place, what is the impact of the program? More often than not, really wasn't a large impact. Those are the easy ones. Most people, when they ask for an accommodation, ask for it because they genuinely need it. People aren't out here just trying to scam the system. People want to work and they want to do so with the best of their abilities. As an organization, are you willing to go to the mat for something, though? This is important because, similar to what I was talking about, the organization I was with sucked at ADA. And they sucked at ADA because they said yes to everything. We ended up having some scenarios in where we were working with kids where there was potentially going to be a service dog on site. And I brought that up to one of the people who were on our legal team, and they said that is an absolute disaster. Other people on the HR team thought it would be an absolute disaster. There are things that you shouldn't do. And if you are firm about it and have it rooted in genuine standing and you are able to hold firm on that, might you have a grievance? Might you have a complaint? Yes, but that's what your legal team is there for. You cannot use the ADA out of fear and just give people what they want, because people are people. And if one person is successfully able to win that, others will too. You are not going to get sued just because you tell somebody no. You are going to get sued if you have inconsistencies in your process, and that is how it works. One of the things that was the toughest, the absolute toughest with ADA, and this is a hot button in the world of employment law, is the whole intermittent leave aspect of things. Now, when we talk leave with FMLA, intermittent FMLA, that exists there for employee protection. But where it's gotten kind of blurry is that you've got people asking for mental health days or being able to call out from work and use the ADA as that reason. To me, that was passive FMLA, and we were granting FMLA leave to people who weren't eligible for it. These were people who had been there a couple of months, brought up a condition, said that this was the accommodation they needed, and because we had done it in the past, we were stuck doing it in the present and probably in the future, and it was not working, and it created a problem, one that was not solved on my way out, and one that is, again, a real hot button issue in the world of employment law. How you do that, up to you. I had my line of where I thought it should go. I was overruled. But when you talk about accommodations, there is a balance. And again, if you allow it for one, you have to allow it for all. That is the danger that you kind of roll into with that. And it can get messy if you are not precise with it. It can cross over with leave and work comp, as I mentioned, probably in those as well. If somebody has an accommodation and it's due to an injury, then that is because then that's kind of how that one rolls. The ADA with leaves, a little bit different of a crossover, but it can happen. I'm trying to think of an example, and I'm not getting one off the top of my head. So that tells you a little bit of kind of the rarity with it. Leaves are pretty straightforward. But again, it matters. It's all about compliance. It's about making sure you've got everything in place. And when you've got somebody who is utilizing an accommodation, you've got to make sure that everything is done the right way. And realistically, there's probably things that you have that could make people's lives easier that you just don't even know about. If you have a work-sanctioned laptop, Windows-based, there is an accommodations and accessibility section that can do dictation, that can change the colors, that can do things where people maybe with a disability can access it better. If you've got standing desks at the workplace, that can be an accommodation. It's not as hard as it seems. It's just understanding the resources you have and being creative with it. At the end of the day, you're trying to make somebody's life at work easier. And if you talk to them about what it is you can provide, what it is they need, you can usually bridge that gap. So that's what I got there. As always, nothing that we have here will save the world, but if one person, just one person, takes what we have here and can utilize it to make things better for themselves or for their employees, that is a win. So we're not going to save the world, but we just don't want to make it worse. As always, if anything resonates, give a like, subscribe, and engage with the platform, Instagram, or the really cool website. And as always, we will see you next time.